All right, Judge, you served on the Court of Appeals then until 1980, is that correct?
Yes. Mm-hmm.
All right. And by now, has your family grown?
My family is growing, and by 1980, when I was running for the Supreme Court, my children were very involved in tennis, and my son Frank, who was 10 years old at the time, won the state 10-year-old division. And as he calls it, he peaked at age 10 because he beat the person that continued to beat him later on in life. And my daughter won the state 12. So it was a big summer for us for your two children to win the state titles in tennis. Helen went on to Florida to play in the Southerns, and Claire and I really weren't able to go with her because we were involved in the campaign. So Cecil Croson took Helen down to Florida, and she didn't win a match because they had such great food and such fun time together.
Obviously, your judgment is not infallible.
Well, that was Claire's idea.
Now, as we sit here in 2006, you've got grandchildren.
Right. Helen is now 38 and has 3 children. Rylan, who's a teenager, 13, and Casey, who's 10, and Clay, who's 7, and my son is an ophthalmologist in Murfreesboro now, and has 2 children, Russell, age 3, and little Rose, age about 1.5. So we've got, that was one of my real reasons to retire, is to get to spend more time with grandchildren, because as I mentioned earlier in the interview, I really didn't get to know Frank that well, ages 1 through 4, and I missed a lot, and so I'm taking advantage of retirement.
And little known fact, Frank signed a contract including a covenant not to compete with his Murfreesboro Medical Group, and that's why you did not participate in Murfreesboro Medical Group v. Udom. Is that right?
That's right, and you were his lawyer when he signed that contract.
Because I knew it was going to happen and it wasn't going to be enforceable anyway. Now, was it your grandchildren that gave you the nickname Judgy Poo?
I guess so. Actually, it was some friends, but they're not real close friends anymore.
Well, now, what I hear is that the name Judgy Poo came from some of your late acquired taste in gambling.
Well, the person that was telling you this was one of the fun things with my son, once I got on the intermediate court and on the Supreme Court, and you've got more time, was doing father-son trips, and we did one down the Grand Canyon, but had to stop in Las Vegas, and that's where Judgy Poo came in.
And I understand from Mr. Frisk that a dealer in Las Vegas gave you that moniker.
Apparently so. It's funny how certain people remember things and others try to forget.
Well, I think Tommy's made it his purpose in life to make sure no one forgets.
I think so, and he got it into this
interview. So we've recorded it now for posterity. Now, you went on the Supreme Court through the process of being nominated by the State Democratic Executive Committee. Is that correct? And that process, you had one vacancy created by the death of Justice Henry, and you competed for the nomination from the State Executive Committee, and then that's what triggered the election between you and Justice George Brown, who had been appointed by Lamar Alexander.
Right.
All right.
And I tell you, the Executive Committee, that was a tough decision for you, because 3 of the people that applied for the seat, myself being one, the other 2, Sissy Daughtry and Al Birch, eventually became members of the court. So it was a tough decision. I felt honored.
All right. So now you've gone from a 3-judge court to a 5-judge court. And explain to us how that affects things and how the tenure of a court serving together can impact the way the court approaches its decision making.
Well, you know, I always describe it as the 74 court, because that's when Joe Henry and the other 4 were together in 74. But I also use it in terms of the 80 court, because that's when I came on board. But you already had 4 members of that court who had served together from 74 to 80. So they had been together for 6 years. I joined this court, and it's interesting. From 80 until 90, we were 5 white males. 3 of us went to Vanderbilt Law School. 2 were in the same had the same teachers because they were there at the same time at Vanderbilt Law School. And you tend to think alike. And so that court was truly the hardest working court I served on, simply because of the jurisdiction that that court had. But it was, you certainly can't say that it was a very diverse court. And then in 90, you have your first woman in Sissy Daughtry. And then in 93, you have your first African-American in Al Birch, first African-American elected to the court in Al Birch. And during that period from 90 until 98, those 8 years, in other words, I've already said for 10 years we only had 6 judges. But the next 8 years we had 9 different judges. So there's a great deal of turnover, but a great deal of diversity. And then from 98 until when I retired in 2005, for a period of 7 years, we only had the same 5 members that were elected in the judicial elections of 98.
You've served twice as Chief Justice, 2 separate terms, is that right? Or 2 separate periods, I should say?
2 separate periods, right.
And was that the selection of the Chief Justice impacted by the different dynamic on the court in terms of its personnel?
Well, the 74 court really couldn't, all 5 members that were new to the court, so that was an interesting phenomenon. And I think most of them wanted to be chief, and so rather than go on seniority, which was still questionable on how you determine seniority, they decided to split it up 19 months for each judge. So from 74 until 90, you automatically rotated into it, and for a period of 19 months. So from January of 89, until September of 90, I served as chief. And then we had a new court. And basically, Charlie O'Brien were the only holdovers, and you have 3 new members.
Charlie O'Brien and yourself?
And myself were the only holdovers. And so the 90 court had 3 new members, and they ran, truthfully, against some incumbent judges. In other words, Sissy Daughtry ran against Judge Harbison, and Riley Anderson ran against Bob Cooper, and in the State Executive Committee. And so it was kind of the old court versus a new court. And so the thought was, which I agreed, that it would probably be good to have a new, fresh Chief Justice from this new group that came on. And Lyle Reed was selected. And so Lyle was selected and served for 4 years. And during that 4 years, I thought was just an excellent chief, in that in 93 we got the Tennessee Plan, which would not have happened if it weren't for Lyle and John Wilder. And in 93 we also got the jurisdiction change, where we became a pure Rule 11 court. And
a pure permissive appeal.
Permissive appeal court.
All your jurisdiction be based on applications for permission
and
to
that
appeal.
one thing had more to do with the changing of the Supreme Court than I think any one thing, because 50% of our workload prior to that time were hearing workers' comp cases. And even the death penalty cases, even though we still hear each death penalty case, they now, as of 93, went through the intermediate court. So I think 93 was a major change in how the court functioned and operated because of jurisdiction.
But yet, isn't it true that if you, for example, look at the period 93 to 2005, you still see a lower and lower percentage of applications being accepted for permission to appeal?
Perhaps so, but the truth of the matter, I think in the years 80 to 90 that I served, we were all aware of the heavy workload that the court had. We would go to Knoxville, and we would have 3 of the 5 days would be workers' comp. And I can recall one time even going over to a Saturday to hear some cases. And that, you're absolutely right, that's not true now. Now the court will go to Knoxville 2.5 to 3 days. But the types of cases they're hearing, I think, are more suited for a Supreme Court. The court still hears workers' comp cases. I mean, they will still grant and hear a workers' comp case, but 50 to 60% of the docket isn't workers' comp.
It's more truly a law development court and not an error correction court.
Very much so.
And is it fair to say, though, that as the Supreme Court has evolved, the Court of Appeals has become more significant in terms of the finality of their decisions and the significance of especially their published opinions?
Much more. I would say 90% of their opinions end up the way they have drafted them. I mean, we deny them. I think we probably take just about 10 to 15%.
And if I remember correctly, you talked about it being a new court in 1990, and in fact, I think your campaign slogan was, or you called yourself, the Court of the 90s. Is that right?
Right.
And it wasn't long after that court was elected in 1990 that the court had the chance again to wrestle with the issue of comparative fault.
That's right.
And that's the issue that you had written about during the 70s and as late as 1980. You now had a change in personnel on the court, and another 12 years had passed without the legislature addressing comparative fault. I know you've called comparative fault, the decision in McIntyre, the most significant decision that you think you were involved in. Can you tell us what you feel comfortable telling us about how that evolved and how comparative fault got adopted and what sorts of issues you were wrestling with?
Well, it's interesting in that in 80, when I came on, it was quite clear that Ray Brock and I were the only two that were interested in even discussing it. And the other three, Harbison, Cooper, and Phones, had good logic and reasons why they didn't want to deal with it. The legislature being one. It was an issue for the legislature to deal with. So when 90 comes along, I had no idea where these others stood, and we campaigned that year and were in the same van, but we never discussed issues like that. I guess we were just discussing the campaign. I had no idea where Lyle Reed, Sissy Daughtry, and Riley Anderson were. I knew that Charlie O'Brien, when he took Ray Brock's seat on the court in '87, he was totally opposed to it. So it went from a 3-2 to a 4-1, my being the only member of the court that was still in favor of discussing it. So when the 90 elections, I had no idea, and the first time it comes up, there are 4 people that say, I think we ought to discuss it. I think we ought to take this case. And part of the discussion was, well, we don't want to take this case unless we're going to do something. And let's give credence to the arguments in the briefs that said it's for the legislature to act. And we were quite aware that the legislature had not acted, and they had had the opportunity to act. So that major hurdle, which was a major hurdle, was discussed really before we granted it. But once we granted it, then we knew in our hearts some form of comparative fault we would have. We knew that Charlie was totally opposed to it, so we thought it would be a 4-1 decision. We then get after oral argument, and what we did not know is that we were so spread out on what type of comparative fault. The pure form of comparative fault was supported by several members of the court. Lyle Reed was at the 49-50%. Charlie O'Brien was still for no form of comparative fault. So for the first time, it really showed me, well, I shouldn't say for the first time, we dealt with some of these type of issues in the court of the 80s, but it truly showed me that if we were going to make a major change in the law, we needed to at least be a 4-1 court, and we knew where the 1 was. So it meant that the 4 of us had to reach some type of agreement, because you do not want to make a major change in the law in a 3-2 decision when, as I indicated, you're having major people leaving the court throughout that period of time. Sissy left and Al Birch took his place, and then you had Penny White came on board and took Charlie O'Brien's place, and then Janice Holder took Penny's place, and it went on until Mickey Barker took Lyle's place. So you kind of had a fruit basket turn over on the court. So for the decision to have any real meaning for the bench and bar, it needed to be 4-1. So for the first time, I saw what real compromise was. I mean, I saw people going from pure 100% comparative fault all the way down to the mid-range. and not feeling good about it, but feeling like this is necessary. And so the court ended up where we ended up on McIntyre decision. And finally, after Charlie O'Brien sits in and listens to almost a year's worth of discussion, he finally was sold on it. To our shock and surprise, Charles said, I can agree with you on that. So it was a 5-0 opinion which sent out a very strong message to the bench and bar.
And in that opinion, you also abolished most forms of joint and several liability. Had that been part of the discussion all along?
Oh, very much part of the discussion. That was part of the give and take. And since that time, I have seen other important cases reach the court where if the court ends up with a 3-2 decision, it really means in a way that they just got worn out and tired of discussing it and just couldn't, the give and take. I mean, people were locked in because we always shoot at least a 4-1 or a 5-0. So a 3-2 decision is not a good decision. We're not proud of the 3-2 decisions because it's not a strong decision.
And of course, what you have is lawyers preserving that same issue in the trial and appellate courts, thinking that the change of one judge might change.
Well, as you mentioned earlier, the sentencing issue, that was a 3-2 opinion. We would have that was an important case, and we would have loved to have had that 4-1, but it was never going to be.
Once the 3-2 decision comes down,
yes,
and then the issue comes back up a few years later, does that then make it more difficult because now you've got the principle of stare decisis involved, and you've got to think in terms of, well, are we comfortable from the standpoint of the court's credibility in changing a rule that we've just adopted? And to what extent does that come into play as you weigh how you'd like to rule in a case versus the context of the precedents that's sitting there already?
Right, that's an excellent question, and that comes up so much. And you will find judges that will write a dissent, and it'll be a sole dissent, maybe it's 4-1. And the majority, the same issue comes up again, and they continue to dissent. But they realize full well that the majority is the majority and that the court has spoken on that issue. And I think if the makeup of the court were to change, even that person who dissented would probably say under stare decisis, you know, even though I didn't agree with them, it is the decision of the court, and under stare decisis and wanting to have uniformity, that they would probably go along with that. In fact, I have seen that occur. So it really takes, for a court to totally change its decision in a 3-year span, really means basically that the court felt like they were in error first go round.
The decision to adopt comparative fault, as you know, has been criticized by some in the legislature and even some judges and lawyers on the basis of separation of powers. The argument that there are some things that should be left to the legislature and the adoption of the type of fault should have been left to the legislature. On the other side of the spectrum, though, we've seen examples during your term as Chief Justice of issues that the legislature has waded into, like the criminal rules of evidence or interlocutory appeals in class actions, issues like that, where the legislature has moved over into areas that have traditionally been part of a core function of the judicial branch. How does the court decide when it's going to go along with a pronouncement of the legislature and when it's going to assert itself in its appropriate role as the decider of issues such as those?
Mm-hmm. You know, I'm just speaking for Frank Drowota and not speaking for the court, obviously, on this. But you know, comparative fault is once again a good example in that the legislature had not acted, even though legislation had been brought before them to act. And I think, and like I said, Bill Harbison and Bob Cooper had an excellent argument that it was for the legislature. And truth of the matter is, had the legislature acted and had they had a commission to study it, and had they had gotten all the special interest groups together, Now, whether they could have come up with anything or not, I don't know. But it was always our feeling. You recall, McIntyre was just a two-car accident, and we couldn't address nearly all of the issues that needed to be addressed. And it took probably 5 or 6 years before we really were able to reach all the issues. So I'm the first to say it would have been better for the legislature to have dealt with that issue, because had they dealt with it, they could have dealt with the broad aspect of the entire thing. So I guess I'm here really, preaching out of both sides of my mouth, because hindsight, had the legislature done it. But the legislature did not do it, and they did not do it for a period of probably about 15 years. And so a majority of the court at that time just felt, well, it's time to act.
So you might not disagree that a comprehensive statutory approach was better, but
No.
at the same time, when the legislature does not act.
And we really didn't see it happening. And so, and we really were convinced, there were only 5 states left that had not adopted comparative fault. And so we just really felt the time had come. And the truth of the matter is, I think both plaintiffs and defense bar are probably okay with comparative fault now after it's worked for so long. I really, as a trial judge and as a defense litigator, I hated really to see senior partners in my law firm go in before a jury and say, if this plaintiff was the least degree at fault, and they would put a big 0 on the chalkboard. And I would see in a rear end accident, juries coming back with a 0 for the defendant. And that truly wasn't justice.
I'm afraid the clock on the wall is going to catch up with us, so I want to hit just a few topics before we run out of time. Are there other decisions that come to mind as important decisions in your career as a Supreme Court judge?
Well, the typical answer is every decision is an important decision, because they are. I mean, by the time they get to the court, the litigants, that's the most important case for them. I guess really cases dealing with domestic relations, to some degree, those are very difficult cases when you're dealing with child custody. And Sissy Daughtry brought a new view to the court, being a woman, and followed by Penny White and Janice Holder. So I guess the diversity that I saw in the later years on the court, particularly from '98 until I retired 7 years later, it was the most diverse court I think we've had in the state, but not diversity based upon gender or race, but a diversity of ideas, because we all 5 graduated from different law schools in different parts of the country. And we just didn't think alike. And that's good. And I think lawyers would be pleased to hear that the 5-member Supreme Court doesn't think alike. So we had many contested issues, but the one thing that the court did have was mutual respect one for the other. And I think, mutual respect for your fellow judges is a necessary ingredient for any appellate court to function properly. And we've had that, and I think we continue to have that.
We've seen some decisions recently that are based upon the state constitution, such as the Nashville Planned Parenthood case in the area of privacy rights. Do you think as we see the United States Supreme Court changing direction, we'll see to the Tennessee Supreme Court and other state Supreme Courts playing a more major role in the fundamental constitutional issues of the day under each state's constitutions?
I think so. And I think, we first saw it in the criminal arena when Bob Cooper wrote his opinion. And I mean, we're talking about, the mid-'80s on that, but it has even gotten more so when we go to these judicial conferences, and particularly Chief Justice's conferences, where you have the opportunity to visit with judges from throughout the country and find out what they're doing. And I mean, we literally have had seminars at Chief Justice's conference on needing to use your state constitution. And you've got certain states that use it more than others, like Oregon perhaps. But in Massachusetts and others, but it is helpful for judges to be with other judges from other states, find out what they're doing. And Tennessee truly is on the cutting edge, and it's kind of fun to see that a southern state is not in the background or on the back burner. And I think the present makeup of the court is exciting. Now, what is going to be exciting in the future is you're going to have a major change on the Tennessee Supreme Court come August 31 with 2 new members. So you will have had, with my retirement less than a year ago and the 2 new, you're going to have 3 new judges within the period of 1 year. And so those that love to study courts are going to love to study the court of September of 06 through 2014, because they will have had major change in the makeup of the court, but you're also going to see great continuity, because hopefully the 5 people that are on there in 06 will remain on there for an extended period of time because they're young, and you've already got 2 women. We could have a 3rd woman, or you could have another minority, African American. This governor has some interesting questions to deal with, but the important thing, and I think he will do it, is appoint based on merit and good legal scholars, and I think it's going to be an important time for the state.
How would you like to have your career as a Supreme Court judge remembered?
Tough question. I guess just remembered as being a fair judge, an honest judge, a hard-working judge. The courts are really open now under the leadership of when Riley was chief. I mean, cameras in the courtrooms and being more accessible. And I have built on to liking the programs that he started, like the Scales Project, which is being more accessible, swearing in attorneys across the state, which we did not do in the 80s, I think is very important, so that families can see their loved ones sworn in to a very important role instead of everybody coming to Nashville. So I've seen a lot of positives, and I guess I'd like for Frank Drowota just to remember as one of the ones on a really good Supreme Court, which I think we have, who worked hard and did his best and was fair and gave everybody a level playing field.
As we look over the horizon, of course we know you're going to live to be at least 101. You're going to spend more time with your grandchildren. You're going to do more traveling. Tell me about this group, Six Fast Feet.
Six Fast Feet, they're not very fast anymore. They've kind of slowed down. They've even taken to the bicycles, You've obviously been talking to some friends of ours. But, I think family and friends and church and the law, these are all part of your life. And friends have been a major part of my life. And we've had groups that used to get together at Percy Warner Park, which is a park with a lot of hills here in Davidson County, and we used to run for hours on Saturday mornings, but we don't do that anymore, so we're into biking and traveling together. So
and that's Tommy Frist and Steve?
And Steve Riven and a guy named Alan Bryan and Dave Malone. They're just a large group of us that really enjoy being together. I guess Tommy is my closest friend, he and Steve, just because Tommy and I have gone back to the 5th grade, and
you know what they say about old friends, they know where you are and they know where you've been.
That's right, that's right.
But you've also accepted, you're president-elect of the YMCA?
CA of Middle Tennessee.
And so,
I've found out that's a large organization. They've got about a $74 million budget and 30-some-odd chapters, facilities around Middle Tennessee. So it's something I'm very excited about and will be time-consuming.
Chief Justice Frank Drowota, this has been a privilege for me to spend this time with you. I could have gone until midnight tonight. We could have talked legal philosophy and politics for another 7 hours, but we're grateful to you for the time you spent. And we know that all of your friends and family and lawyer friends and judge friends and historians of the state of Tennessee will be greatly benefited from you giving us the history of not only your life, but your wonderful years of public service to the Tennessee judiciary.
Thank you, Buck, and thank Melinda. Thank you for being here.